Sure.
Good afternoon, everybody. We hope all of you all are doing well and staying safe. Thank you for joining us for the first reading session that's organized by the Technology Law Reading Group, or TLRG. TLRG aims to initiate a conversation amongst the academic cohort at OP Jindal Global University and create student engagement and spread awareness about policy developments around these disruptive technologies. Our guest speaker for today is Professor Altaf Marsouf from the Nanyang Business School in Singapore. Prior to joining NBS, he spent 3 years at the Dixon Poon School of Law at King's College London, where he completed his doctoral research investigating approaches to and challenges in holding internet intermediaries accountable to and accountable for infringements of trademark rights. His research at King's was the basis for his book titled Internet Intermediaries and Trademark Rights, which was published in July 2019. Today, he will be delivering a lecture on internet intermediaries and IP enforcement, its opportunities and challenges. We'd like to thank Professor Marsouf for agreeing to deliver this inaugural lecture. We would first like to invite Professor Indranath Gupta to deliver the welcome address. Professor Gupta is a professor at the Jindal Global Law School and the Dean of Research and Control.
Well, I think you're very kind, Pallavi. I think that should be enough. But I think we should focus more on our host today. Our guest today, I beg your pardon. But is it okay if I start, Pallavi?
Yes.
Okay, wonderful. First, thank you very much for inviting me to deliver this welcome address. I'm sure there are better people, but very kind, and I'm extremely grateful to Professor Altaf Marsouf. And Altaf has been a great friend and colleague for about the last 3-4 years, and we have had the opportunity of working together, and we work on many projects. When we were discussing about whom to call, whom to invite, I said there can be no better person than Professor Altaf from Nanyang Business School. And he has done some brilliant work, not only his book, recently published book, but he has done some brilliant work in the area of IP and intermediaries, their liability. He's distinguished scholar in this area and has worked extensively in Australia and with different scholars. So Altaf, we'd like to apologize if we have missed out on any, of your achievements. But it's a great pleasure to have you amongst us. So thank you, Pallavi. Thank you, Arya. Thank you, Krishna, for inviting me and to make this happen. It's been a great effort, that has gone. From our students and Professor Krishna. They have really conceived all this idea and has culminated into this first lecture. Talking about, intermediaries, I mean, of course, Altaf, I would like you to sort of, talk, but, as my 2 cents, if I may, when I look at intermediaries, I mean, if you compare with intermediaries, say 20 years back, this is a time, when we had the Information Technology Act in 2000 in India, and even before that, the DMCA. And if you look at the situation with intermediaries, say in 2021, I see a gray cloud. I do not know, I'm sorry whether I sound radical, but I see a gray cloud. It's not very clear as to what they are expected to do and expected to follow and what the norms are. I see intermediaries facing an existential challenge, meaning, they are no longer intermediaries. So for instance, if you are, been sort of asked to proactively monitor all contents, without any exceptions, essentially that would mean that you are a security or a gatekeeper, which I don't think is a role of an intermediary. But then again, That's my opinion. Um, and I believe that we have to look at different jurisdictions. Of course, it includes India, Singapore, United States, and maybe Article 17 of the DSM as well, and just to see that where intermediaries are at this time. But whether the gray cloud would be soon over, and there would be silver lining the horizon. So that's something that we want to sort of discuss today, and I'm sure your talk would give us a lot of hope and also a great deal of clarity as to where we are with intermediaries. Furthermore, I think we also have to look at intermediaries and how they should function with advancement of in some in technology, and its technology has been the real sort of um, challenge for many of us, be it an intermediary, be it a stakeholder involved in processing information and so on and so forth. But what can the technology, how can technology help intermediaries to proactively monitor, or whether there would be a change in situation with advancement in technology? Or would it sort of be sort of a difficult phase which is yet to come, which would make intermediaries a lot more liable than they are? I mean, it's not about making intermediaries liable, that's okay. But the question is that why can't we set clear ground rules just to ensure that the innovation doesn't hamper, and intermediaries continue to flourish? I mean, going back to the old judgment even before the DMCA, and the idea was not to destroy this innovation prone infrastructure. And where have we come from that stage? I mean, are we going back to the to the stage where we probably would have more regulations, and therefore that would dampen innovation in some ways? And we see I'm sure you're going to talk a little bit about the DSM. We see each and every EU directive, for that matter, talk specifically about data flow and how to ensure that there is no impediment as a result of a directive. So if that is the overarching objective, how that would essentially reconcile with the amount of responsibilities that are now being sort of pushed towards intermediaries. So I'll stop here, and I thank again Pallavi, Arya, Krishna, and all my other students, and of course yourself for inviting this invitation of ours. And I think it's a great beginning, and I'm sure there will be many such talks which the Technology Law Reading Group would be organizing. Thank you again.
Thank you, Professor Indranath, for your insights into this topic. I would now like to invite Professor Altaf to begin the session. Thank you.
Thank you very much, Arya, for organizing this session along with your team, and also Professor Krishna and Professor Gupta. I'm sure they have been of tremendous support to you all. I think that we should stop a little bit to acknowledge the fact that you have organized this during rather strange times, and I understand that there are many challenges that you face in India as well as all of us throughout the world. So this clearly demonstrates your resilience as a group of students, and also your yearning for learning. So a big congratulations to all of you. I think I should start with that. I also find it quite interesting that your team had decided to focus on intermediaries, and I was telling you just before we started that over the last 1 year, I think we have been relying on intermediaries of various kinds more than ever before. And I think they have been of tremendous support for us to get through this period of time. If not for them, probably we would have clearly tested our sanity levels. So I think that we have much to thank the various intermediaries that we have come across, particularly in the context of the internet. So the reason why I decided to focus on IP enforcement and intermediaries is because just as much as intermediaries have given us all these facilities and they have tremendously helped us in numerous ways to collaborate and communicate with each other, at times their platforms and the environment that they have created have also been abused by various actors. And these abuses could include various things from violations of criminal law to violation of personal rights, and also includes infringements of intellectual property. And for that reason, I thought that we could focus about how we can make use of these intermediaries, in a sense, to enforce IP rights. So there are opportunities. And at the same time, what are the challenges that we face? And what are the safeguards that we should take in order to make sure that we preserve a right balance between the protection of private proprietary rights and the public interest, right? But let me at this point share my screen. So please bear with me. Right. Okay, and I think that one of the first points that I wanted to make is that intermediaries are nothing new, to be honest. We have known intermediaries from time immemorial, right? Even before the internet. But what was significant when the internet started blooming in the early 90s is that people started talking about disintermediation. They thought that the internet would eliminate the need for intermediaries. But in reality, what happened was quite the opposite, right? We not only saw traditional intermediaries sort of getting into the online sphere, we also saw new types of intermediaries emerging from time to time. So in essence, the internet has given rise to a mushrooming of various types of intermediaries, right? So I think that is something important to note. But when we are trying to deal with intermediaries and how and thinking about the question of how we can make use of them to enforce the law, I think that it is important to have a very thorough understanding about their technological functions as well as their place in the internet, if you consider it as a hierarchy. Okay, and for this reason, I would like to rely on a taxonomy that was set out in Gianni Riordan's book titled The Liability of Internet Intermediaries, which I happen to use in writing my PhD thesis and then subsequent book as well. And I think that this gives a very good understanding about where the different intermediaries that we come across on the internet are. And if you take a note of this, there are mainly three layers. The physical is basically the physical infrastructure that we see, that we perhaps don't even see, because these are all provided in very specific specialized places, and we hardly come across them when we make use of the internet. And then you have the network layer, which provides us with the connectivity needed. And then you have what Riordan calls the application layer. And that is what we most interact with. Facebook, Google, and various other platforms that we interact with are according to Riordan, located in the application layer. So what Riordan is trying to say here is that we need to focus on where the intermediary is before deciding on what kind of responsibility that we should sort of vest on the intermediaries in terms of enforcing the law, right? And there are many reasons why we might want to focus on intermediaries, particularly when it comes to enforcing the law and private rights. And one of the main reasons from an economic perspective that is often cited is that these intermediaries are lowest or cheapest cost avoiders, right? Justice Arnold, as he then was, in Cartier against Sky, which was the first case to ever award an injunction against an internet service provider to protect trademark rights in the UK, and perhaps, if I'm not wrong, in the whole world, said that it is economically more efficient to require intermediaries to, enforce our rights, as opposed to getting right holders to enforce their rights in the online environment. And he considered this from an economic or cost perspective. And there are some reasons for this, which I have noted on this slide, which I will very briefly set out. So obviously, I think it is very easy for us to identify the relevant service providers that are providing services which are used for various infringements. We are going to find it more difficult to identify individual infringers because of the relative anonymity that the internet provides these infringers, and all of us, of course, right? So it is easier to identify the intermediary as opposed to individual infringers. So economically speaking, it is less costly for us to litigate against intermediaries or to seek the assistance of intermediaries as opposed to going after infringers. And also, secondly, intermediaries, I would call them choke points or nodes, because the reality is that all of us, if we were to get access to the internet or to use the internet for a certain purpose, we need to make use of some kind of service provider, because we simply don't have the finances or the infrastructure to do this ourselves. It is prohibitively costly for us, right? So all of us need to go through one intermediary or other, and therefore it makes sense for us to employ these intermediaries to assess the legality of content that is transmitted and disseminated through them, right? And of course, we can argue that these intermediaries have more control over the relevant content, infringing or otherwise, than we have over such content. So it makes sense for us to utilize these intermediaries for the purposes of enforcing our rights. And finally, the ripple effects argument. So if you find that there are multiple infringements being committed around the world, it is going to be quite costly for you to take action against all of these individual instances of infringement. You would rather isolate the intermediaries involved and then, so to say, nip it at the bud and prevent infringements from happening from the intermediary, as opposed to going after each and every instance of infringement. So I believe that there is great utility in focusing on intermediaries from a rights enforcement perspective. But as with any approach, we must be cautious about this, because some argue that, I think Leichman and Posner have said that we must be cautious before determining which intermediary should be responsible in enforcing our rights, or to be responsible for taking on liability for infringements. And the reason for this is because it is true that these intermediaries do provide the infrastructure or the environment within which various infringements takes place, right? So if you consider this from a purely cause and effect point of view, you might argue that but for these intermediaries, these infringements would not have taken place. So therefore, there is legitimacy in holding them accountable. But at the same time, I think that as lawyers, we are used to, or we have trained ourselves to consider responsibility from a more legalistic point of view, and we look for legal justifications before we actually can allocate responsibility or liability on a certain actor. So we are often going to be looking at things like moral blameworthiness, right? So morally speaking, who is responsible for committing these infringements? Is it the intermediary, or is it someone else who is more directly involved in these infringements. So be that as it may, I think that from a practical perspective, we need to think hard before sort of pointing at a particular intermediary to enforce rights or to engage in various policing or surveillance activities. And also, I would like to note that although it might make sense to use intermediaries to detect certain types of content, like, for instance, viruses, spam, I would say even things like malicious software and so on, right? Because they probably have a certain kind of trait to it which can be identified. And probably if you're dealing with viruses, it is either a virus or it is not. And there is no third-party rights involved when we are dealing with these kinds of things. But when it comes to things like IP infringements or content that could potentially infringe intellectual property rights, we are looking at the need to exercise human judgment over it, right? Because how do we know whether something is an infringement or not? We need to apply a series of laws, principles, legal principles in relation to complex facts. And there are defenses involved, such as fair use or independent rights might come into play, such as free speech. So because of these complexities, it is quite dangerous to really vest these intermediaries, which are private actors with no constitutional accountability, to determine the rights of individuals. So we need to think twice before we empower these intermediaries to engage in such activities, right? Simply because it may be more complex and difficult for them to discern between lawful and unlawful content, particularly in the area of IP and other private rights. And I think I touched upon the third bullet point on this slide as well, and that is when you require these intermediaries to engage in an exercise of removing content or employing various technical measures to deal with an infringement, there may be unintended consequences that might come into play, which could result in collateral damage. I call them collateral damage because there might be certain impact felt when it comes to legitimate activities, right? So we need to make sure that when intermediaries are employed for the purposes of IP enforcement, that third-party activities which are legitimate are not hindered by these efforts. Okay, so we need to be careful before we engage in using intermediaries for IP enforcement. Now, I just wanted to touch a little bit on the early developments. I think Professor Gupta, in his introduction, did mention the fact that before the DMCA and all these other laws which specifically deal with intermediaries in various contexts, there were certain developments that led, in particular, the US Congress to react in a certain way. And these are those cases that you see on this slide, right? I'm not going into details here, but just to note that the copyright cases, for instance, they found a bulletin board service directly liable for copyright infringement. Now, I wonder whether you know what a bulletin board service is. Think of it as a host or online host like YouTube from the past. Okay, it is like your notice board at school. Of course, in law school, it's probably monitored. But here you have a forum where you can simply upload content so that they can be viewed by everyone else who are subscribers to that service, right? So in Playboy against Frena, someone had uploaded certain content which had copyright, and it was downloaded by many people, whereas Frena was merely the service provider who provided this platform. He didn't engage in reproducing, he didn't engage in any kind of activity that violated copyright. But despite that, the US court in this instance decided that Frena was directly liable for copyright infringement. In Mafia, it was quite a similar setup. It involved the Sega games. Some of you may be familiar with this. It was a similar sharing platform, but in Mafia, they were more involved in the infringements. But even in Mafia, in first instance, during the injunction hearing, if I'm not wrong, the judge decided that there was a case, a prima facie case for direct copyright infringement, which kind of suggests that despite being a mere intermediary, you are now suddenly caught up in being liable for primary copyright infringement. Of course, all of these things were later settled in the Religious Technology Center or Netcom case. But even so, the Netcom case left it open that there might be a degree of secondary or accessorial liability on the part of intermediaries when their services are utilized for copyright infringement. So clearly, what was happening before the DMCA and all these laws were enacted is that there was an increasing trend of internet intermediaries becoming liable or at least getting entangled in litigation for the services that they were providing in respect of certain infringements or violation of private rights that took place in their platforms, which were committed by their users, right? So the legislator found that this was not a very good trend. It was not conducive to the development of internet technology. At that time, you must remember, in the early 90s, things were very primitive. It's not like what it was today. So they were worried about how things would, how these increase in liability would impact the development of the internet and intermediaries. So with that in mind, the Congress enacted two pieces of legislation which I think are important. The first is the Communications Decency Act, which basically resulted in intermediaries becoming completely immune from any kind of liability in respect of content that were transmitted on their platforms. But this immunity was not extended to IP infringements and in respect of certain areas of criminal law. So for that reason, when it came to IP and indeed copyright and trademarks, intermediaries still remain open to the threat of liability, right? So that is what happened when the Communications Decency Act was enacted, Section 230. And scholars have argued that Section 230 is the savior of free speech and so on, which I think is probably true. But there are also scholars who argue that complete immunity being granted to intermediaries isn't really the best idea, because they probably won't be motivated to police their network anyway, because they are completely immune from liability in the first place. So there is no nudge towards doing something to remedy illegality on your platforms. But be that as it may, what we are concerned with is the Digital Millennium Copyright Act, which for the first time set up something like a safe harbor for intermediaries that potentially could become entangled in copyright disputes, right? So I'm sure that you probably are fully aware about how the Digital Millennium Copyright Act works. I'm sure Professor Indranath and other members of the faculty may have already taught you this during the various courses you have taken. But to basically give you the crux of it, liability under the DMCA is based on the intermediary's knowledge of a given infringement, its control over the means of infringement, and indeed its failure to remove the infringement after having acquired this knowledge of infringement, right? So that's the formula. In the trademark context, there isn't really a statute that mirrors the DMCA. So that's an interesting disparity in the US context. Although in the European Union, the e-commerce directive, articles 12 to 15 of the e-commerce directive sort of it granted immunity or conditional immunity to service providers across the board in respect of all areas of law. But in the US context, it was only limited. It was limited to the copyright context. But for the trademark context, we saw some developments through judicial innovation, and a similar regime was basically developed through the Inwood Laboratories formula, which was then modified to apply to the online context, which essentially replicated what you find in the DMCA, but for the trademark context in a slightly different formula. But I would argue that the outcomes are probably the same, right? Now, what is interesting about all of this is that because liability on the part of intermediaries is based on knowledge of infringements and their failure to take steps to remedy those infringements or eradicate those infringements, this basically gave rise to the practice of notice and takedown. So what this means is that if you're a copyright owner or if you're a trademark proprietor, and if you see a violation of your rights, let's say in Facebook or on YouTube, what you would do is send the relevant intermediary a notice of infringement. And once that is served, then they would have the requisite knowledge of infringement. And then, of course, they need to address the infringement expeditiously. Failure to do that would open them to liability, right? So that's how notice and takedown works, essentially. So what is good about it is that it is very efficient. You don't need to go through court, right? You simply serve a notice, and it is low cost and it is fast, right? But the problem with this approach is that it is extrajudicial, meaning there is no determination by a judge or an independent administrative body regarding whether or not the content that has been identified in a notice of infringement is actually infringing or not. That decision is made by the intermediary. Now, as I said before, these are private actors. They are motivated mainly by their economic interests and their interests in avoiding liability at all costs, presumably. So therefore, some scholars have seriously questioned whether or not notice and takedown is a conducive approach to reaching a balance in the enforcement of IP rights vis-a-vis third-party interests, right? So I think I would like to leave you with, some of the scholars' comments who have looked at notice and takedown, and they have raised various concerns about this practice. So for instance, Wendy Selzer, an American scholar, has been very vocal about this, and she has said that the DMCA is responsible for the restriction of internet speech. And that she has gone on to say that this is because of the incentive structure that the DMCA creates for online intermediaries, right? And then another scholar, Julie Adler, says that one practical result of notice and takedown provisions is that intermediaries enforcing them fail to account for whether a particular user-generated work is fair use, right? So we can see that concerns are being raised on the part of scholars about whether or not using intermediaries via the notice and takedown process is actually going to reach the right balance, because the system can be abused. And there is a danger of violation of third-party interests, right? And I have also on this slide listed out 3 empirical studies: the Liberty study, the Multatuli project, and the Urban Quilter study, which have actually gone into this from an empirical perspective. And the Urban Quilter study was quite interesting because they considered over 800 notices that Google had received, and they found that quite a bit, I think approximately 30% or more of these notices were having problems with them, and that they raise questions which were ideally, or which should ideally be decided by a court of law, right? And it's not appropriate in their view that these notices or the legal issues arising from these notices be determined by private actors, right? So this is the problem or the challenge when it comes to the enforcement of IP rights using the practice of notice and takedown, which essentially requires private intermediaries to engage in a form of dispute resolution, right? And what is more interesting is that today we are seeing the phenomenon of robo takedown. So the graph that you see on this slide is pretty interesting. You would see that it is exponential, right? And it's starting at 2012 and ending at 2016. I couldn't get an updated version of this graph, but I presume it is continuing exponentially to date. But in essence, what this graph is telling you is that in March 2016, during a week in March 2016, Google had received over 20 million notices of infringement just within the speck of a week. Okay, and I think that is a very significant amount, even for an entity like Google to handle. And you may ask, why is this? Why are there so many notices being sent? The reason for that is because copyright owners are now adopting the practice of using artificial intelligence to crawl the internet and to identify instances of copyright infringement and to automatically send notices of infringement to the relevant intermediary concerned. So as a result of this practice, intermediaries too have had to adapt, because after all, if they are served with a notice, they need to take expeditious action to avoid liability, right? So they had to innovate, and now what they are doing is that they too are using artificial intelligence to tackle notices of infringement, and in fact, at times to automatically take potentially infringing material offline. Okay, so we are seeing some developments here with how intermediaries are reacting to the notice and takedown process. From a legislative point of view, there is also a shift that we are seeing. I think Professor Gupta expressly mentioned this in his introduction when he referred to the EU Digital Single Market Directive and Article 17 of the directive. Now, I just have the directive with me, which I thought is very interesting, and I really would like to share this with you. Article 17 of the DSM directive expressly says that when online content sharing platforms provide access to copyrighted works on their platforms, they are to be regarded as committing acts of communication to the public or making works available to the public. Now, what does that tell us? It basically is telling us that if the works that these intermediaries are disseminating or making available to the public happen to be infringing content, they would be regarded as having communicated those works to the public, which is a right that is exclusively vested in copyright owners. In essence, what this article is doing is that it is treating intermediaries as potential primary infringers. Now, I find that quite interesting because of the fact that it reminds me of what was taking place in the early 90s. So we have gone on a complete U-turn back to the early 90s in terms of looking at how these intermediaries are to be treated in terms of their roles, right? And then it goes on to say various things that before these intermediaries can share things and disseminate content to the public, that they must obtain the requisite authorization from the copyright owners and so on. And then it provides, in accordance with high industry standards of professional diligence, they must make best efforts to ensure the unavailability of specific works and other subject matter for which right holders have provided the service providers with the relevant and necessary information. So they must make best efforts to ensure that works in respect of which they have been given notice of any infringing work in relation to those works do not come into their platforms by way of uploads or any other means. And then what is more interesting is that the provision goes on to say that they must act expeditiously if they receive a notice of infringement, which is fine. But again, it provides that they must also make best efforts to prevent future uploads of such content. Now that is very striking, because when you say they must take best efforts to prevent future uploads, it is basically telling you that they must monitor their platforms. I mean, scholars have basically argued this. The provision itself does not say this. The provision itself does not say that you must use automation, but the crux of it is that it seems to be the only way of achieving or meeting the requirements of Article 17. And I think many scholars have voiced their concerns about this, right? And I think the graph that you see on this slide is a reflection, perhaps, of the use of automated technologies to remove content ex ante, before their legality is even determined by a judicial body or administrative authority, using automated means, right? So as you can see, the graph that you see reflects automated flagging, which resulted in removal of videos on YouTube. And within the spec of April to June 2020, last year, approximately or just over 10 million videos have been removed using automated techniques by YouTube. So that again is a significant amount for that period of time, as opposed to user generated, or rather removal of content which resulted from a user sending a notice of infringement, is much less when you consider in comparison in this graph. So I feel that there are concerns about using automation on the part of these intermediaries in dealing with copyright and other IP infringements. I just want to check how long do I have?
Sir, you can go on. We still have about 2-3 minutes left.
3 minutes, okay. Good to know. Okay, so the rest of my presentation was mainly to talk about another technique, which is, I would say, much more, an approach which is a little safer in terms of the outcomes that might be reached, because it is a judicially supervised process, and that, of course, is injunctive relief, right? So we know that there are many cases that have been already filed in court in the UK, in Australia, Singapore, and India, where copyright owners and even trademark proprietors have sought injunctions against internet service providers, so that certain websites that are flagrantly infringing, or websites that contain counterfeit material, counterfeit goods, are removed, not really removed, but these ISPs then work to block access to them so that users in a particular country cannot access these websites anymore. So I think the idea is that the infringement still exists. You're not removing the infringement, but its impact is mitigated, so to say, because people don't have access to it, right? So the good thing about this approach is that it is injunctive relief, which means that it goes through court. So there is that safeguard. But if you really look at some of the details, I have identified in the course of my book as well as in some papers that I had published in a series of papers that I published in the EIPR, there are some challenges with the use of injunctive relief. But I will leave you with some comments that I found very interesting from someone from India, in fact, a student from India who had written on dynamic injunctions. And this student had compared the Singaporean approach with the Indian approach. So you might have come across the case of UTV software, right? And in that case, I think in India, for the first time, a dynamic injunction was issued. So why a dynamic injunction is useful is because when a particular website is blocked, right? Once the website operator gets to know of this, they can essentially move to a new website, which then would circumvent the blocking, right? In terms of technical impact. So when you shift IP addresses, or when you shift your domain name, or when you shift your URL, these are possible means of circumventing a blocking measure. And what a dynamic injunction does is that it allows the copyright owner or the relevant IP proprietor to essentially require the ISP to update the technical measures so that the technical measures extend to all of the instances of infringements of a particular website that might arise in the future because of circumvention on the part of the website operators. So you don't really need to go through the whole process of litigating all over again. It's just that you simply update the technical side of things so that the new website is also equally blocked. So you need to keep doing this every time the website operator keeps shifting its presence, right? Now in Singapore, and indeed in the UK, what happens is that right holders can do this without going back to court. They can simply inform the ISP, and they can require the ISP to block the new location, right? But in India, and I believe in Australia as well, in the Roadshow case, they did mention this fact that if the website operator shifts the location, you can't really require the ISP to take the necessary technical steps to update the blocking measure. You need to come back to court. It needs to be assessed. And once there is a new order by the judge, then you implement it by updating the technical measures. So Pratik Dixit, who wrote this article, which is published in the Journal of World Intellectual Property, suggests that the Indian approach or the Australian approach, which adopts a similar technique, is better because it is much more safer in terms of ensuring that that you don't do things without judicial supervision, so to say. But I'm just wondering, given the amount of circumvention that might take place, whether it might really be something that a court would want to burden itself with, given the loss delays we are having already in our court system, whether a judge would want to burden himself with having to entertain these kinds of applications, which probably might overwhelm the court system. So I think that these are things that we probably need to consider and find ways of overcoming by innovating in how we deal with enforcement of IP rights and making use of intermediaries for our purposes. I think that, let me leave you with this. I think that intermediaries are not necessarily our enemies. I think that they're not our foes. We need to make use of them for the purposes of ensuring that our rights are protected. But we must do so within a very certain and specific legal framework that provides for safeguards and ensures that third-party interests and rights are protected at the same time. Okay, so I would like to end on that note, and I'm happy to take your questions if you have any, and please feel free to update me about what's happening in India as well in this regard. I would be happy to update myself about that. Thank you.
Thank you, Professor. So if anybody has any questions, Professor can take it right now. So please feel free to ask questions or doubts that you may have with respect to intermediaries and IP enforcement.
I think I will start first, and then if there are any more questions from the students, you can then follow me. So thank you very much, Professor. First of all, it was a fantastic discussion on this topic. I think all of the students must have understood the relevance, contemporary relevance, as well as the impact that it has on our expression on internet, as well as protection of rights and the need for balancing them, and the kind of challenges, that very real challenges, which do not, I believe, have any easy solutions. But on this very point, in fact, taking cue from the last point that you mentioned, that while it is a more principled way to go to the courts first, in cases of where there's a copyright infringing material on a particular website, it is being hosted. Definitely, it can become kind of tedious and cumbersome for the court as well as for the rights holder because of the delays. And there are certain instances where those delays can be particularly costly. For instance, where there is a show or a movie which has recently been released, which is likely to make money for the creators. But if they go to the courts and it causes them to delay, the nature of internet is such that the matter would have been, or the material would have been shared so many times by the time an order comes from the court. So what do you think is the most optimum way forward in cases like this? Can we create a separate category, or is there a separate mechanism that can be there for this?
Well, I think that's a very good question. I think that, I feel that there's no easy answer to this, because on the one hand, we need to ensure that copyright is protected efficiently. And as you say, I fully agree with you on the point that time is a matter of essence, particularly when it comes to the film industry and even the music industry. So for that reason, I think perhaps maybe one approach may be to adopt the procedure for ex parte injunctions. We know that in most jurisdictions, we are able to secure ex parte injunctions on an urgent basis when there is an imminent threat to your rights. So I suppose we might be able to convince a judge to issue an injunction without delay, but that would also allow us some time to address whether or not there is actually an issue at stake through a judicial process. Of course, we can go back to the notice and takedown approach and require the intermediaries themselves to take steps. As the current law stands, that is always a possibility. And I suppose that right holders would obviously make use of that approach. But whether or not that is the best approach, well, I think when you consider the critiques against the notice and takedown approach, I think that there is a danger about third-party rights being affected. So maybe it might be worth perhaps coming up with a gradated response, perhaps. So when there are, I suppose we need to come up with a classification of, how infringements take place. So we do know that some infringements are really obvious and clearly they are clear-cut infringements. So in those instances, I don't suppose that there would be any danger in allowing an intermediary to expeditiously remove that infringement at stake, and of course, still allowing the relevant aggrieved party to challenge that removal through counter notification processes and all that. Whereas in respect of other areas where there is a genuine dispute, then perhaps we should not let intermediaries to get involved in that kind of situation and instead prefer an approach which is judicially supervised. In fact, in writing my doctoral thesis, I did come across a proposal similar to this for the specific context of trademarks, where the author suggested a gradated response like this. And I think that might be an approach that may be adopted. Even when it comes to the use of artificial intelligence. I mean, when we think of artificial intelligence, we are basically divesting our thinking process to an artificial construct to reach a certain outcome or conclusion. I feel that we can trust AI to a certain extent to engage in automation and to filter content appropriately. But again, we must do so carefully. So for instance, when the threat is extremely high, so for example, if you think of content which could potentially sort of promote terrorism, for example. So for that kind of content, we could adopt a situation where the AI or intermediary could directly flag the content and remove it. But then there always has to be a human review process. At this stage, I don't think automated technologies are still mature enough to deal with the thinking process that we engage in deciding matters. So I think that to answer your question, we need to probably take a gradated response in that sense.
Sure. Thank you. That's actually a very helpful perspective for looking at this particular thing. Thank you.
Professor Altaf?
Yes, hello, Lakshmi.
Hi, Professor. It's great to see you again. I saw you during the PIRA conference. Unfortunately, we could not interact much.
I see. Right.
Yes, Professor. So it's been a great lecture, and thank you so much for that eye-opening lecture. But I just had one question. So while I've also been, I've been just about trying to understand this concept, and I've come across many scholars who, like you, have been advocating injunctive relief very, in a very staunch manner. But one of the problems, and I think that's the elephant in the room, is that the law is tending to follow the technology. So since the intermediaries are able to come across, since the intermediaries have the technology and have the means to control the content, it can also be argued that the law is merely just following the kind of capabilities that the intermediaries have. So in these circumstances, and now that intermediaries are actually morphing into something more than what we have envisaged traditionally for them, what would be your comments on the approach of injunctive relief in such circumstances?
Well, that's a good question once again. I think if I understood you correctly, I think you mentioned the law following the technology. I think that is quite true. I think always we have taken a reactive approach to these things. We wait for the law, we wait for the technology to develop, and then we react through legislative or other judicial innovation to deal with the new situations. I feel that, well, as it stands right now, we need to adopt some remedy. So we currently have a legal framework which we can make use of. But I feel that as we go forward, probably we need to focus more on how we develop the technology itself. I feel that is where IP proprietors could really invest, because I think for copyright, for instance, we have got technology protection measures, right? And these have been developed with the intent of protecting copyright in that particular context. But this is where technology is really stepping in and assisting us with enforcing copyright. And I think perhaps what must happen is something similar to that, where technology is developed so that in this front too, we can rely on these technologies without thinking too much about the potential issues, or rather, we need to come up with technology so that we won't be too concerned about its implications on third-party interests. So the technology has to be balanced and safe to use. So I think the way forward is for us to work with these intermediaries and encourage innovation as a matter of policy that would enable these intermediaries to ensure that their platforms are more conducive for legitimate commerce. Yeah, so I don't know whether I answered your question or whether I went completely off track, but I think that should be the way forward.
All right. Thank you, Professor. Thank you so much.
You're welcome.
Can I ask a question?
Sure, Indranath, please go ahead.
So, Altaf, these days we are, working too much, discussing about privacy by design, at different levels, right?
Yeah.
I was thinking, can we do a flagging by design? That's a new term, that where intermediaries would be flagging contents, right? Infringing contents, right? Based on the signatures of copyright owners, for that matter, whatever products that they develop, or films, or songs, and so on and so forth. At least that would take away a bunch of materials that are clearly violation, that would construe as violating the proprietary rights. Then we probably would be left with, fair use and other aspects, which are borderline, where probably we need more human intervention.
Absolutely. Yeah, that's a very good suggestion, I think. I mean, it's a good term to use, I guess. Just to add to what, I guess you asked me a question, but you also provided basically the solution to all what we have been discussing in your question itself. But I think that just to add to what you said, in Singapore, we are seeing some amendments taking place in the Copyright Act. I'm not really sure whether these are already passed. I don't think so. They're still in the stage of consulting the public and securing our opinion about various things. But one of the interesting exceptions to copyright is where someone needs to use infringing works for the purposes of training AI in order to detect infringements. So that has been included as a very specific exception in the Copyright Act. So I just remembered that because you asked this question, and I suspect that the idea behind that is that potentially what they are hoping to do is to make use of artificial intelligence to allow it to learn through our experience of infringements, so that it would have the capacity to quickly identify different kinds of infringements and maybe even classify infringements at least. And that would be a good way of deciding on which path we should take in relation to very specific content that we find is controversial. I see that someone has raised his or her hand.
Yes, sir. Hello, sir. I just have a very tiny question. Thank you so much for this. So, can you tell us a little more about what immediate impact the concept of a non-fungible token, NFTs, using blockchain has on the world of copyright? The immediate impact that we're seeing today.
Okay, to be honest, I must be honest up front. I haven't really looked at blockchain as much. But can you explain what non-tangible or non-fungible token is?
So NFT is basically it's a unit of data on the blockchain which can be used to certify digital assets like anything. It can be photos, videos, audio, any kind of digital file can be certified using. So you never have to delve into the question that who is the original creator of this photo, video, or audio. The person who's associated to the particular bit of NFT code identifies as the owner of that copyright. So I think this eliminates a lot of
uncertainty.
Correct.
Right. Yes. Okay. I get your point now. Okay. So I haven't. So blockchain has been an area which is a bit overwhelming for me, and I'm still learning it. But and one of my colleagues at the business school is actually dealing with blockchain, and in my discussions with her, I have understood that they are using blockchain now to deal with things like paying royalties to copyright holders in the music industry. So I presume that it is a good way of trying to identify who the author of a particular work is. But I guess my concern about this is that we need to make sure that the person or the entity that is certifying that someone is the author of a particular work, or perhaps the owner of a particular patent, and so on, is actually a recognized body. So perhaps maybe what is best is for this technology to be embedded within our IP system so that IP officers can make use of them, so that there is integrity in how this information is stored and even shared across the world. So if you think of patents, for example, I think this can be very useful, perhaps in relation to patent searches and so on. I'm just basically thinking out loud here, but I presume that it would reduce the energy that we might need to put in to deal with preliminary matters, like establishing your ownership and so on. To some extent, this is all achieved through registration processes. So if you do own a trademark and you have a trademark certificate, you don't need to go through the hassle of proving your rights, okay? But I guess for copyright in most jurisdictions, we don't have a registration system. So perhaps this technology may be used as an alternative to overcome that obstacle, perhaps. So I think that there is utility in utilizing blockchain for the purposes of IP.
Thank you so much, sir.
You're welcome.
At the end of the day, I mean, if I may quickly add, with your permission, Altaf.
Sure.
I think we did it before, and we are trying to do it now. We are trying to remove intermediaries, right? Either through blockchain,
Yes.
or through at different times. We are ensuring that intermediaries have a lesser role to play. But even if we consider advanced technologies to sort of remove infringing products, right, that would still be an intermediary. So it cannot be one-to-one conversation. I think there is always a triangle, if not more, right, nodal points in any given communication. I think that is how technology is, or we have to use our, come up with all our technology. Ourselves, we carry our own technology. I guess that's not the solution, but it'd be very difficult to remove intermediary from this question.
That's very true. I think even like as I think Akash raised the question regarding blockchain. I guess the idea is that you might be able to use blockchain to try and eliminate certain intermediaries, as you said, but in the end, we might, as you rightly said, end up with more intermediaries dealing with this specific technology. So again, we see the cycle of disintermediation coming into the picture. So it's like a cycle, I presume. Each time we come up with a new technology, we perceive certain things, but in reality, what might happen is completely different. But I think intermediaries will certainly remain in the equation for a long time to come.
But is there, if I may have a follow-up sort of discussion point, is there a, something that I started my, welcome remarks with, is there an existential challenge that you see? I mean, going back to the 1995 case involving religious, forgetting the name, the 1990 we actually led to the DMC, other than the two cases which you mentioned.
The Frena case, right?
The Frena and the Sega case, right?
Yeah.
So do you see that the existential challenge that was asked in 1995, which led to the DMC, we would see that again coming back in 2021 because DMCs, I beg your pardon, the intermediaries are again pushed to the wall. And I'm not saying, I'm not taking a side, but it seems that, have seen a full circle in the last 30 years or so. It seems that we are almost going to that stage where we started from. And then again, we need a sort of another DMCA plus or something similar to safeguard intermediaries.
Sure. I mean, that possibly might happen, but my gut feeling is that it might not go back to that same extreme. I think because of the fact that technology has now evolved, and I'm pretty hopeful that who is making policy is actually aware of how the technology is evolving, and actually the response to require intermediaries to, at least in some instances, get more involved is hopefully a decision that is backed by technology and good policy. But the problem, as many have said, the problem is that still the technology hasn't really reached a level where we can trust it. So I feel that what might happen is not that intermediaries will be required to be safeguarded in any sense. They will probably do their job that is tasked of them, but we might have to face the consequence of that. So we may be seeing many of our content that we otherwise would have been having access to freely suddenly disappearing. So I guess it might be a negative impact on consumers in the end. That's
sorry to keep just something that struck me right now. Then are we looking at a different name for intermediaries? Are we going to call them agents henceforth? That they are no longer intermediaries?
Yeah, I think that is something which we would probably need to seriously consider, because at the end of the day, when they are required to do more work to protect rights, I guess the reason for that is because potentially they are losing their sort of classification as intermediaries. So in that sense, we might, at least in terms of nomenclature, not see them in the same way that we used to see our old intermediaries. So in that sense, we may be moving away from intermediaries to a different breed of entities. That's an interesting idea.
I think there is a question. Thank you.
So Abhijay has one question.
Yeah, hi Abhijay.
Good afternoon, Professor. Am I audible?
Good afternoon.
My question, so in light of the Baba Ramdev versus Facebook case, it was adjudicated in 2019, saw discussion around global takedown orders and whether they're necessarily a judicial overreach. Do you see global takedowns as A, justifiable, and B, are they sort of an infringement of other nations' rights to regulate IP within their borders? And I think this is particularly interesting in light of a discussion of UTV and the discussion of Hydra sites.
Right. Okay. I guess the challenge here is that, okay, on the one hand, IP rights in particular are territorial. And because of that, sometimes you might have rights in certain jurisdictions, but not in others. So at least to that extent, global takedowns may have an impact in countries where access to such content could have been made legitimately. But I guess the impact here is that who decides what is infringing and who decides what is not? That is another problem. For instance, if you're talking about Facebook, they have their own standards, and sometimes we don't agree with their standard simply because they are influenced by certain cultural traits that we find in the US. And not everyone, say in Asia, would sort of feel that those are standards that are applicable to them. in their respective jurisdictions. So I see as the impact of global takedowns is that sometimes there could be inconsistencies for the basis of the takedown, depending on where you're from. And I guess that might be a controversial issue that you might need to grapple with before anything is made global. So any standard, whether it is, standards for certifying something or standards in respect of what is free speech and what is unlawful and all that, I don't think it is, it's very, very challenging to have a global standard. I suppose you might come up with common denominators to come up with something, come up with something workable. But still, there might be subtle nuances that we may need to take into account. So I think that would be the key challenge I see.
Professor, may I ask one final question? Lakshmi here again.
Sure.
Yes. So given that you were also speaking about the best efforts that the intermediaries tend to do in light of the law that is shaped in front of them, we have some really interesting bits about Facebook Supreme Courts coming in. So what is your opinion regarding those kinds of organizations, basically wings of the intermediaries themselves sitting down and deciding whether certain content is infringing or certain content is illegal in any manner? What is your opinion on that?
Well, I think it is very important that that all of us are represented in those efforts. Recently I had and I saw an incident in Sri Lanka where someone was sent some obscene images on his Facebook chat, and then he went public about it. And for some reason, Facebook's policies, or based on Facebook's policies, that effort of this person to publicize this indecent act itself was taken down as a violation of Facebook standards. So I think that, well, for one thing, Facebook's own standards may be controversial. And on the other hand, I think it is also important to consider the fact that at the end of the day, they are a monopoly in a sense. They dominate the social media space. So for that reason, it's very dangerous in allowing an entity that has a basic monopoly in a certain area to determine these things without any kind of public accountability. So I think that we need to have more localized mechanisms where these intermediaries interact with, say, statutory bodies or some relevant entity within a jurisdiction so that they can work with cooperation to deal with localized issues. So that's my view on that. I'm a bit skeptical about how successful something like that, what you suggested that Facebook is trying to achieve, would be.
Thank you, Professor.
You're welcome.
Thank you so much, Professor, for agreeing to hold this lecture with us. We at TLRG are grateful for you taking out the time to come and deliver this very insightful and informative talk. And I'm confident that all the participants have benefited immensely from your session, just as we have. So with this, we would like to conclude today's session with a thanks to all the participants for their enthusiastic participation. And we hope to see all of you again in the next TLRG session. Thank you so much, Professor Alta, for...
And can I also say that to everyone in India and everywhere, anyone else joining in from anywhere else, do stay safe during these tough times, and hope to see you again at some point at conferences or wherever we meet. Thank you very much for having me.
Thank you, Professor.
Thank you, Alta. Thank you, Krishna.
Thank you.
Thank you very much, Professor. Thank you. Thank you, everyone.
Professor, thank you.
Thank you, Professor.